Here.
Commissioner Causey,
Here.
Chair Eberly,
Here.
Commissioner Shea, Vice Chair Kraus,
Here.
Commissioner Smith, Commissioner Stimler.
Here.
Chair, you have a quorum.
Thank you. We're going to move on to public comment. Now it's the time for public comment on items not on the agenda. This section of the agenda is where any person can speak to the HRC and express their views. These are the views of individuals and not the views of the city or the Human Relations Commission. In Palo Alto, we are committed to a culture of acceptance where all members of our diverse community feel included, safe, and respected. We encourage all speakers to honor these values and express their message without intimidation, discrimination, or language that disrespects any person. The public should know, however, that the Brown Act requires cities to accept public comment, and the U.S. Constitution provides strong support for freedom of speech. The city honors these rights, even if we strongly disagree with the speaker's message, unless the speaker disrupts the meeting or violates the HRC's rules of conduct. Thank you. Do we have any commenters?
Yes, we have Avram F.
Okay, go ahead, Avram.
From Finkelstein, and I have a piece made by my very good friend Doug Minkler. We went to high school together. We graduated in 1967, and as the audience can see, it says "Stop U.S. Aid to Israel." And this piece was done in 1988, and this is when I first learned about the duplicity of the multiple pro-Israeli lobbies. Stop U.S. Aid to Israel. In 1988, U.S. Aid to Israel $3.8 billion, almost $11 million a day. Israel has used this money to continue its 20 years of illegal occupation of the Palestinian West Bank and Gaza. Now we know it's Lebanon and Syria and on and on. Ending U.S. aid can bring this agonizing conflict to a just and peaceful solution. Now, this is a little history that he gave on this piece, and it reads as follows. During my 36 years as a poster maker, no piece that I have created has been censored more than the Stop the U.S. Aid to Israel piece. When I made the poster in 1988, it was displayed in restaurants, grocery stores, bakeries, all over Berkeley. Within 2 weeks from the time of the posting, all of the posters had been removed. The merchants were told in no uncertain terms by the Israeli lobby, you show this poster here and your business will suffer. Over the years, I have continued to exhibit this piece with similar censorship results. Now, moving on, it says here, below is a letter written in response to a critic who attempted to persuade the director of La Peña Culture Center to remove my piece. The director of the La Peña Center turned the request of that individual down. Here's Mr. Minkler's letter to that person. Dear Ms. or Mr. Distractor, your complaint to the Culture Center has been referred to me for my response. I am the artist who created this poster. You would like removed your statement that I depicted Israeli soldiers with racial features of anti-Semitic cartoons. Seems to be an attempt by you to distract people from the message of my poster, that is to stop U.S. government from giving $11 million a day to Israel by attacking me, the artist, as racist. You are attempting to remove the issue of U.S. aid and illegality of Israel occupation from the debate. Your observation that I have depicted an Israeli soldier as unbecoming and unflattering is accurate, but there's no proof that I'm anti-Semitic. It's only proof that my depictions when attacking similar depictions when confronting police corruption, Contras in Nicaragua, I use similar abstractions. As we have special art, so should we have special art rules for Israeli villains? Be assured my intentions are not to have special art rules for Israelis. Be assured my intentions are not to fuel anti-Semitism. I'm a vocal advocate for equality. Unfortunately, Israelis' discriminatory practice and military aggression against non-Jews makes my job increasingly difficult. Thank you. Anybody that wants a copy of this piece, reach out to me.
Chair, I don't see that any of the individuals on Zoom have raised their hand for oral communication for items not on the agenda.
Okay, thank you.
Okay.
We're going to move on to any agenda changes additions and deletions. I believe our 15-minute break is an addition. Is that an addition to the agenda? Because it's not on the
No.
copy that I have.
I think there is the official copy that was posted on the website and is in front of City Hall, and that does include the break. So I
Okay,
think these were just internal copies, but the official outside copies do have that.
Oh, okay, great. I do want to let everybody know that we are going to be taking, oh, yeah, mine doesn't have it.
Yeah, that's the one.
A 15-minute break to attend the Downtown Housing Plan Open House, which is happening right here. And as members of the HRC, we are not allowed to engage in dialogue about the plan, but we can go and visit and talk to them, just not talk amongst ourselves, because that would be a violation of the Brown Act. All right, so the next, since there are no other changes, additions, and deletions, we're going to move on to approval of minutes. Do I have a motion to approve the minutes from the last meeting?
I move to approve the minutes.
Okay, Commissioner Stimler,
I will second that.
thank you. And Commissioner Barr seconds it. We're going to go ahead and take a vote. Commissioner Shea,
Aye.
Commissioner Barr,
I,
Commissioner Stimler,
Aye.
Commissioner Causey,
Aye.
or Eberly, aye. Motion passes.
Oh, Michelle.
Oh, I'm sorry. Commissioner, Chair, oh, I'm God. Vice Chair Kraus.
Aye.
Thank you. Sorry. Okay. Please,
Yeah, I'll
help you remember. I'm not used to Zoom anymore. Okay. Our first business item then is we're going to have a public hearing. It's the initial public discussion of fair chance housing policy. Approaches regarding use of criminal history information and Palo Alto rental housing decisions. And the way we're going to do it is we're going to have a presentation. Minka, would you be kind enough to introduce the presenters?
Mhm.
And then after the presentation, we are going to open for public comment on this item. So if anybody wants to comment on this item, stay tuned. And after public comment, we'll go ahead and have discussion / questions. Part of the hearing is to hear from the public, so I really would like us to hear before we discuss. Thank you. Go ahead,
Great.
Minka.
Well, I'm very pleased to have three of my colleagues here to present to you the fair chance ordinance that they have all been working on really hard. I'm going to give their names because I don't always get positions correctly, so they can add that to the mix. But Julia Knight and Rebecca Atkinson from our planning department, and then Maddie Salah from our city attorney's office. So they can, oh, I'm sorry, thank you. See, it's just like not being used to Zoom. And Captain James Reichschneider from the police department is also with us tonight, and he is on Zoom, and he will be available for questions as well. So I'll turn it over to my colleagues here.
Thank you all for this opportunity to discuss fair chance housing policies tonight. And we've already been introduced. And if we could go to the next slide. I'll begin with a brief staff presentation. And as Minka mentioned, Captain Reichschneider is joining virtually. And if any questions for the police department, if anyone had any, we'd request just due to some timing constraints that those questions be addressed to Captain Reichschneider first. And I'll go ahead and proceed. Hold on just a second. Tonight's meeting is a milestone as the first detailed public discussion of potential fair chance housing policies. By now, you've had the chance to review the staff report. We tried to support a conversation that considers the needs of our entire community. We tried to the end, we've incorporated information from social science research, other policymaking initiatives, and information on what a draft ordinance would include. And we look forward to hearing from both HRC commissioners and members of the public tonight. Next slide. For context, staff received direction to work on fair chance housing policies from City Council. The HRC continued to advocate for this topic in 2023. Subsequently, our adopted housing element and the identified council priorities for the year office also referenced this work. The Housing Ad Hoc Committee recently recommended that the HRC consider policy approaches prior to council consideration. Next slide. Fair chance housing policies align with policies on fair housing, anti-discrimination, and renters' rights. They specify how and when criminal history information can or cannot be used in rental housing decisions. Fair chance housing local ordinances contain certain basics, such as definitions, applicability, exemptions, and exceptions, as well as remedies and enforcement provisions. Next slide, please. Our staff report provides an overview of the legal context for this work, including key information from California's Fair Employment and Housing Act and the recent Ninth Circuit ruling in Yim versus Seattle. The city has the ability to establish local fair chance housing policies as long as they are no less protective than state law. Next slide, please. Thank you. As outlined in the staff report, fair chance housing policies attempt to provide a fair opportunity for persons with a criminal history to compete for rental housing. Research shows that housing stability is key for promoting access to employment, healthcare, and social services, as well as reducing the risks of homelessness and recidivism. Next slide. Thank you. Oh, thank you. While commercially available databases and records may appear to be both accessible and reliable, research has shown that they're often incomplete or inaccurate, along with the other challenges explained in the staff report. Next slide, please. We've outlined some of the basic components of fair chance housing policies in the staff report listed on this slide. These components would be incorporated into any draft ordinance, regardless of a specific policy approach option recommended by the HRC or raised during public comments this evening. Next slide. This slide is going to list 2 fair chance housing policy options under consideration. The first one here, option 1, doesn't totally prevent the use of criminal history information in housing decisions. Instead, it limits the information landlords may consider and is coupled with certain procedural protections for renters, such as requiring landlords to give a conditional housing offer to an otherwise qualified renter before conducting a criminal history check. We'll break this down further in coming slides. Under option 2, landlords may consider criminal history information under only narrow circumstances when required by state or federal law. Next slide, please. Here are the policy approach options again, alongside staff's initial assessment of the pros and cons of each. If you could advance, thank you. We hope to gain further insights tonight regarding these. Generally, option 1 is more procedurally heavy for landlords. However, there may be greater benefits of this approach to both landlords and renters. Option 2 is more procedurally clear and straightforward, but does not offer the specific procedural protections for renters, and it offers less authority to landlords. Next slide, please. To illustrate further, option 1 can have look-back periods, if you advance the slide, thank you, which we would want your feedback on. Additionally, here are some examples of procedural protections, which we'd also want to know if you would like to add any more. In contrast, option 2 would not incorporate these components. Next slide. In council's original motion, council asked for an analysis of consequences, both intended and unintended. Through this public process, the HRC and community members may identify additional potential consequences, both positive and negative. Currently, staff believes that this list here on the slide applies equally to both policy approach options presented for consideration. However, option 1 may introduce more implementation considerations for landlords, even if they ultimately prefer this approach. Next slide, please. Staff proposes this initial public hearing with the HRC and members of the public to receive feedback on the information presented, as well as future public outreach efforts and forthcoming public hearings before City Council. Next slide, please. Thank you. We've agendized all of the fair chance housing policy topic and welcome feedback on all, but specifically, we are requesting an HRC recommendation of support for one of the policy approach options presented, as well as specific support for council consideration of fair chance housing policies. Next slide. Regarding the options, we can refer back to the previous slides or this one where we are showing what we'd like feedback on in terms of look back period duration and any additional procedural protections. Thank you very much.
Thank you. Elena, do we have, I guess we'll go on to public comment before we start discussing and asking questions. So this is the time for public comment on this item, please.
So I don't have any hands raised. Oh, I do. So we'll go, what do we go to? We have one in person. Okay. You have 2 in person and 1 online. So when you get the clock up, I'll go to the person online first.
So as a criminal defense attorney, retired.
Wait 1 second.
We're not ready yet.
Yeah.
Okay, I guess we'll go to Mr. Finkelstein and then we'll go to the person online. So we'll just give my colleague a chance to just get the clock up.
Okay, so as a criminal defense attorney, retired public defender, I think it behooves the HRC, if you really want to get the real impact of the discriminatory laws that keep people with that have been formerly incarcerated out of housing. And what that does is you need to bring folks that have been formerly incarcerated and get their stories and get how extraordinarily difficult it is to do that. And then when we're dealing with the police who engage in racially disproportionate, or I should say racially discriminatory law practices of all type, including in this city, because I grew up here, soon to be 76 years old and have 2 biracial sons, they get stopped all the time. And there's a lot of animosity towards African Americans who we all know are disproportionately incarcerated in this state and in this country. So I would recommend Silicon Valley Debug. They have a group of extraordinarily articulate folks who've been and done time in the prisons and the local jails, who rehabilitated so that they can talk to you directly. I don't even think, as a public defender, having spent many years representing people that were unhoused, that I can adequately converse with you on those kind of issues. Fortunately, never formally incarcerated, and therefore I don't have a basis for, I grew up here in privileged Palo Alto. So I would highly recommend, and I'll be happy to give you names. You've got Raj Jayadev, the founder of Silicon Valley Debug. I also work with the NAACP, Sean Allen. We can bring a lot of folks to this conversation that can talk from an experiential basis, on an experiential basis. So having a bunch of white folks like myself or other folks that haven't been incarcerated, I just think it is an intellectually dishonest way to start that important conversation. So let me know. I'm happy to help out in recruiting folks that would come here and talk to the Human Relations Commission so that you have a real basis to hear people's stories about what it's like to be denied job opportunity after job opportunity, housing opportunity after housing opportunity, because they are formerly incarcerated. Thank you.
Thank you. The next speaker is online is Amy. Amy, go ahead. You have 3 minutes, please.
Hi, I don't know how to get my picture going, but I'm here. My name is Amy Zucker Morgenstern, Reverend Amy Zucker Morgenstern. I've been the minister of the Unitarian Universalist congregation on Charleston Road for 21 years, and I want to speak in strong support of a fair chance housing ordinance. Very, very happy that the city is considering this, and I hope the Human Relations Commission will strongly recommend it. If people are to rebuild their lives after paying their debt to society, as the staff report said, they need stable housing. It's the anchor of so many other things. And as you probably know, there are so many laws that make it more and more difficult for people to be employed, housed, and so on after coming out of prison. It's obviously just feeds the recidivism rate and the despair of people who are trying to rebuild their lives. Our criminal justice system leaves too many people who are not dangerous to others with a significant stigma. And as Mr. Finkelstein just said, this is especially true for many racial minorities who are discriminated against throughout the criminal justice system. All the way along are much, much more likely to be convicted, sent to prison, have long sentences, et cetera, for the same crimes as white people. Finally, I just want to say I take this stance because of my religious values as a Unitarian Universalist, my calling as a clergy person, and my moral commitment to ending white supremacy and to housing everybody. I really hope that the Human Relations Commission will recommend this ordinance, and I particularly favor option 1 as recommended by Project Sentinel. Thank you so much for your time.
Thank you. Our next speaker is Emil B. Emil, go ahead, please.
Hi, my name is Anil Babar with the California Apartment Association. I'm here today to speak on this ordinance and questioning the necessity of the ordinance has yet to be established. The state back in 2020 passed regulations that restricted the use of criminal history when evaluating tenants. And the existence of these regulations bring into question why Palo Alto would need to enact a parallel ordinance and outsource this enforcement to the legal system. The local adoption of a fair chance ordinance, even if slightly different, would create confusion for renters. Under the existing system, if a tenant has reason to believe a property owner did not follow state regulations, they can sue them for their failure, exactly like the proposal before you. However, state regulations take it one step further by allowing the tenant to bring a complaint to the Civil Rights Department if they don't have the resources themselves to hire an attorney. The CRD can investigate the claims and can take legal action on behalf of the tenant, but the CRD cannot enforce local laws because they're not equipped to or authorized to, thus creating a patchwork of laws that will add confusion. Instead, the city should focus its resources on educating its residents on the existing protections available to them. We, as a California Apartment Association, strongly encourage the HRC to recognize that the state laws already exist and recognize the fact that we do not need to go any further in adopting this patchwork of unnecessary and duplicative ordinances. Thank you.
Thank you. I see no other further hands. I'm not sure if Elena. Okay. That's all we have. Thank you.
Okay, we're gonna go on to questions and discussion. Does anybody have a question? Yes, Commissioner Barr.
Yes, my question I was involved in the opening of the Opportunity Center for the homeless, and the manager was the Santa Clara County Housing Authority, and this question came up. And what we did agree on was that, for example, a prior drug offense does not disqualify, but there may be a evidence of danger to others. And danger to others would qualify for not offering rent. I'm wondering about this issue, and an example of someone who was actually put into a mental hospital for 3 days while they cleared out his apartment was hoarding disorder, where there's a fire danger because of so much stuff in an apartment or a room. So that was an example of danger to others. So I just wanted to ask, is this issue of danger to others one of the factors that is considered?
Thank you for that question. Under the two policy approach options, if there was a local ordinance that had a fair chance housing policy under option 2, the criminal history would only be considered to the extent required by state or federal law. So that would mean that even if there was a history, unless it was required for, and the city attorney's office could correct me if I'm mistaken, in that case, there would just be a very limited number of limited amount of criminal history information that could be considered. It would be just very, it wouldn't necessarily have some of those nuances that you are speaking of in regard to the discussion around the Opportunity Center. Under option 1, there, because option 2 is more of a blanket prohibition. Option 1 has the opportunity for landlords to consider certain types of criminal history, like it would have to be like an actual conviction, right? As opposed to something that is not fully processed, or, making sure that due process was followed. And so then within that, it would be only directly related convictions. And so directly related has some definitions, and maybe you could explain that a little bit further.
Sure. So the conviction would have to be directly related.
It's not on.
There we go. Just had to push a little harder. The conviction would have to be directly related to a permissible non-discriminatory interest of the landlord, such as protecting the safety of other residents of the property or of the landlord or their agents. So in that case, in the case of a situation where it would represent a danger to others to have the person living there, the landlord would be able to take that conviction into consideration. In a situation where that was not the case and the landlord couldn't tie the conviction to one of their permissible interests, then the landlord would not be able to consider that criminal history information in the housing decision. Under option 1. Yes, under option 1.
Thank you, Commissioner Barr. Any other questions right now? Commissioner Simler?
Oh. Michelle, do you have a
Vice Chair
question?
Krause?
It's not a question, but more of a comment. May I do that?
Yes.
I want to thank the group for doing an extensive report. When we first considered this at the HRC, the chair and I sat and reviewed extensive information on fair chance ordinances in California and around the country. Rebecca, your team has done extraordinary work, and I want to thank you. And that doesn't come easily from me. So when you want to go through points, let's do that, but I wanted to make that comment. Thank you.
Thank you.
Clarifying questions at this point.
Well, go ahead.
I think I'm still just a little bit confused about the difference between the state law and what this is recommending. So it sounds like the state law says that only, what did you call it, related offenses can be considered. But it seems like related could be pretty broadly interpreted. So a drug offense, well, drugs make people more erratic. They make it harder to stay employed. They make it harder to pay your bills. They may make you more violent. Like, does that mean that like all drug related offenses are considered applicable criminal history for a rental application still?
No, it is a case by case evaluation, and under option one, the landlord would be required to justify that in written form, giving the renter or the applicant a paper trail so that if they then wanted to go to court and say the landlord didn't adequately make the case that this is directly related to one of their permissible interests in keeping their housing accommodations safe, for instance, they would have the opportunity to do that based on the written statement of reasons that the landlord would be required to give them. Yes, sorry about that. Do you want me to repeat any element of that answer? Yeah. Yep. And I'll add one significant difference between the state law and what staff is proposing. I'll say two significant differences. One is in state law, there are certain elements of there are certain procedural protections that apply, but those are fact-specific, context-driven elements of a discrimination case. So in that case, the plaintiff, the renter, or the applicant would be making a case to the court that they were discriminated against based on their membership in a protected class. And the court, in evaluating whether the landlord had an alternative that was feasible and less discriminatory, would look at all of those procedural protections as elements of a fact-driven inquiry into whether or not they had another option that would have had a less discriminatory effect. What staff is proposing is a hard and fast rule saying you must adopt these procedural protections. Similarly, staff is proposing an additional substantive limit on what criminal history information landlords may consider in the form of a look-back period. The state law doesn't have that. They're proposing that you would say, in no case may a conviction older than 3 years from the date of sentencing be considered directly related. And that's based on information that the risk of recidivism reduces with time.
Sorry, just one more follow-up on the similar point. For the second option, you keep saying that there's, unless it's required by law. Can you talk a little bit about what the requirements by law are?
Sure. These situations are rare. For instance, there is law applicable to certain federally funded housing providers that require them to disqualify people with certain kinds of convictions related to methamphetamines. That's just one example. There aren't too many others.
Is sex offense one of them as
Sex
well?
offense is one of them.
Okay. Michelle, I'm sorry. Do you have a question or a comment?
Can we clearly clarify, one of the exemptions that staff has recommended is that sex offense falls into the exemptions of whatever is adopted by the city. I just wanted to be really clear on that. We're not moving sex offenders into residential buildings without a clear understanding of the extent of that impact. Staff, am I correct on that?
There are a couple terms out there, like exemptions and exceptions. And exemptions are like when, someone's looking for someone to be a roommate, right? Like, so they would be exempted from the fair chance housing policies, right? So exemption, but exception to the fair chance would be when a landlord is required to do a check based on state or federal law, in which case, if they're required to do the sex offender check, or check the sex offenders list, then there's nothing in this local version that would preempt that.
That would only be if it's subsidized, like HUD housing. Is that right?
I'll clarify. Staff is proposing a draft ordinance that includes a carve out for checking the sex offender registry.
I mean, sex offenders can still, they live places, they need to register, and then they might not be able to live, close to schools or parks or whatever.
I think you're also saying that a landlord could potentially look you up on the sex registry and make your decision whether or not to rent on you based on that.
That's right.
But is that by law already?
Yes.
Yes, if it's a HUD housing, but not. Is that right?
State law requires folks to be able to search the state sex offender registry for the protection of those at risk.
Oh,
Not just HUD housing.
Oh, okay, great, thank you.
There's not a situation here in which a landlord in Palo Alto would not be able to check whether or not a potential applicant or existing renter had been registered as a sex offender.
Because it's covered by the state, so that's good. Thank you.
I have a few questions, and I'm gonna, it sounds like you're recommending option 1 versus option 2. Is that correct?
Staff isn't making a recommendation of one policy option over the other at this time, but we would like to know if this commission has a recommendation.
So you would like us to recommend one option over the other? Okay. It's just, it seemed from the list that maybe option 1, because of the way that you had the pros and the cons, seemed like the preferred option. Okay. Now, I'm trying to understand the remedy here. On both option 1 or option 2, the remedy would be a civil suit.
Yes.
Now, I've applied for places in Palo Alto to rent places, and they either turned you down or didn't and never gave you an explanation. So does that mean that somehow, if you have a criminal history, you're going to have to prove that you were turned down because of your criminal history?
Yes, and the way this ordinance would ensure that is it would require, the way that option 1 would ensure this is it would require the landlord to give a conditional offer to an otherwise qualified applicant before running their criminal history check. And then if they rescind that conditional offer after running the criminal history check, they're required to provide a written statement of reasons and required to provide the applicant with an opportunity to present mitigating information.
Okay. Now, how do you know that the landlord did not run the criminal history before? Before they gave the conditional offer?
I don't think that we would know that if someone did do a violation of the procedures. Would that be correct? Would that be correct? I mean,
Right.
People, could run a red light and we wouldn't know, like that kind of thing, so I don't necessarily know, but the procedures are clearly outlined. And if someone could prove that it indeed happened without giving them the notice and following the procedures, then they would have, the opportunity to do the remedy.
So just to clarify, what the person would fill out their application with enough information that the landlord could run a criminal background check. And we are hoping that they do not run it. They run everything else, their credit history or whatever, give a conditional offer, and only at that point would they be able to run the criminal history check. But there's no way to make sure that they're actually doing that, right?
Correct.
What information is needed to run a criminal history? Is it different
I
than
mean,
what's needed? Could you ask for that information afterwards? Like, could you make it illegal to ask for whatever is necessary to run a criminal history check during the application process until a conditional offer is given?
I mean, I've done background checks on myself and other people, you know, you can just go into these databases and so forth,
So
so.
it's, yeah, okay.
As a practical matter.
So there's no like special, I don't know, social security number or something.
It would be difficult to really track,
Yeah.
unfortunately. But I guess just to clarify, and correct me if I'm wrong here, colleagues, but right now there's really not any limitation at all. Nothing precluding landlords or those renting, you know, units from doing this background check at any point. And so we could either put a blanket prohibition on it and say you can't do it unless it's like sex offender or something like that, where under state law, the landlord has that right to look into it. Or you could take a more nuanced approach, which is option one. And that's just, it's a more complicated approach, not saying it's better or worse, but that's why it has like a lot more bullet points on the slides and things like that, because it's having these sort of special conditions under which a landlord could look into criminal history and perhaps when they can look into it, and also requiring how they communicate to the potential tenant or existing tenant that they renter, excuse me, that they have completed this process.
Okay, thank you.
Good.
Sorry, but the thing that is preventing them from doing it now is the state law that says unless an offense is related, that they can't take it into account, right?
No, I think they're doing it right now. There's
They do.
nothing.
Oh, so there's no state law that prohibits you from running a criminal history for any reason and denying someone a.
State law prohibits discrimination based on certain protected classes. Criminal history is not a protected class, but if you as a plaintiff can go to court and prove that a landlord's practice based on criminal history has a discriminatory effect based on your protected class, and there isn't an available alternative that would serve the landlord's interests in a less and there
Okay.
is an alternative that would serve the landlord's interest in a less discriminatory way, then you
Yeah.
can make out a case in court.
But it's a
there is no-
pretty tricky case to make, that you as a convicted criminal were discriminated against not because of your criminal background, but because of your race or gender.
It's a little bit more complicated than
Okay.
that. You don't need to prove that the landlord intended to discriminate against you
Yeah.
based on your race or your gender, for instance, although that is also prohibited by state law.
Yeah,
Separately, you can make out a case that this landlord's practice has a discriminatory impact based on, for instance, race, as there is data that running somebody's criminal history check would. And then if you can show that there was an available alternative for the landlord to serve their interests in a way that is less discriminatory, then you have a chance of winning that case.
and does that happen? Do you have a sense of how common that is?
Can't
In terms of like
comment on
conviction,
that.
or like in terms of like lawsuits that have been shown in the defendant's favor either way or not?
Yeah, it's not data that
No,
we have off the top
No,
of our head.
nothing. Okay, thank you.
Commissioner Barr, and then we're going to go to Vice Chair Krause.
Yeah, just independent of these laws, if a person requests a criminal background check on somebody else, is the fact that they requested the check a matter of public record? Not the content of the check, but the fact that they requested a check.
As far as I know, no, just because most of the criminal background checks are run by commercial providers. And so those are private corporations that I assume wouldn't be subject to the same sort of public records request as if it was being run by a city department or something like that. and you probably saw in the staff report too, one of the things that makes this issue challenging and where we really value your input is that a lot of the commercially available criminal background check services are not necessarily super reliable. Sometimes they have inaccurate information. Lots of people have the same name as other people. And there's, considerations like that as to, whether or not the information landlords are even potentially receiving when they pay a somewhat nominal fee to receive a background check is true and accurate information for the individual they're considering to rent their unit to.
Vice Chair Kraus.
Is there a possibility, if we choose to recommend option 1, that we could build in some stipulations for penalties and fees for landlords that routinely violate the criminal background check factor? Could we be explicit in that, and in some way have an incentive for them to be able to be good citizens? What do you think?
I think as part of the recommendations or motions or discussion tonight, it's possible to add additional things that you would recommend staff and council consider, including in fair chance housing policies. And things like that might be like additional enforcement tools and so forth. As we mentioned in the staff report, there are limitations on staff resources relative to enforcement and so forth. But if there were particular ideas that that would be recommended for consideration, that could be included in the feedback tonight.
Thank you.
Thank you. Any other questions?
Do you have more questions?
Well, I'll go ahead, Commissioner Simler, then I'll go.
My question is just about the public testimony. I feel like this is a pretty significant conversation to be having without a lot of representation from organizations and people who would be affected by this. I'm just curious if we have any additional opportunity to seek public feedback, or maybe that would just be when the council hears this.
So staff was able to reach out to a number of organizations to notify them of tonight's hearing. We reached out to organizations that have expressed past interest in renter protection related policies here in Palo Alto. Due to some time limitations, we weren't able to cast a wider net in that notification. This obviously was a publicly noticed meeting, so it was available, but we didn't get to do direct outreach. And staff does have the intent and hope that if this is recommended to move on to a council discussion, to cast that wider net and reach out to more organizations and potentially some of those individuals who have been directly impacted or experienced these sorts of issues in the past, with the idea that we'd really like at council to have as much diverse perspective on this as possible.
Can I just add something? I did, as a liaison to our homeless service providers, I did provide information on the meeting to them because I know that criminal history has been a barrier to some unhoused people being able to obtain housing. So that group of providers in the community was notified.
Thank you, Minka. I echo what Vice Chair Kraus said. I would be interested in additional, can't remember the words that you guys use, but looking at possible penalties for landlords who do this constantly. I do feel that it would be very difficult to show a pattern of discrimination. And I'm wondering how you think we might solve that. How are we going to be able to show a pattern? Maybe the city needs to create an office where people can go complaint to see if there is a pattern. Otherwise, I don't know how we're going to be able to show a pattern. Because right now, the only thing they'll be able to do is sue civilly. And honestly, first of all, it is so difficult to rent in Palo Alto to begin with. I mean, the amount of money that you need to make to be able to qualify for these places is astronomical. So, and the landlords are able to deny for any reason, really. They don't tell you why they deny your application. I don't understand why we wouldn't go with option 2 versus option 1 in the sense that we would create less barriers so that if you are denied and you know that, well, when I do this rental calculation, I make enough money for this place, but because I have but I also have a DUI conviction from 2 years ago, maybe that's the reason that they denied me. So I feel that option 2 would make it a little bit easier for people to be able to prove that nexus versus creating more barriers. Because honestly, I'm just not sure how many landlords are not going to just run the criminal check to begin with. So, any questions or comments? Commissioner Collins?
Thank you. So one thing I did want to flag is like, this is coming at a time where our rental registry is going to be implemented, and a huge, one of the main purposes of our rental registry, it is to help us identify patterns of discriminatory behavior. So we do have that resource available with this resource. I am leaning towards option 1 because I used to work in our housing nonprofits with renters who either were very close to having nowhere to live or were facing eviction. And the people who face eviction in Palo Alto are always seniors, single parents, and members of marginalized communities, usually Middle Eastern or Latinx. When we had tenants facing discrimination, it was so hard to prove. And I'm leaning towards option 1 because it does create that paper trail. And I think that is going to be so valuable. And I am also leaning and supporting our vice chair's recommendation of implementing an incentive or a fine for people to follow the law. In that case, I think that's really worthwhile. Just wanted to say really phenomenal work on this. When I was working in our housing nonprofits, we did not think this was going to move forward in Palo Alto. So I am so glad that this has come before us. Completely support having people with that lived experience speak when this comes before council. I'm really glad to see this helps advance our housing element and our equity goals of giving more people the opportunity to live in Palo Alto. There's so many parts of this report that I just think are phenomenal. I think flagging how databases can be inaccurate, Alta Housing's and Project Sentinel's input on how they do rarely see this come up. And just reminding everyone that like housing is a safety issue, and like when this is an important part of someone's rehabilitation, it aligns with the reparations presentation we saw a few months back, and people are just safer to everyone when they are in housing. Thank you.
Katie, can I ask you a question? But don't you think that option 2, just the blanket prohibition, will be easier to enforce and easier? Like, yeah, this one leaves a paper trail, but landlords like that, just more paper doesn't actually solve the problem because people can still run criminal record checks, whereas in the second option, they can't even look at it.
It's just so, if I'm given the option of a paper trail or not a paper trail, having worked with tenants, like it's just having worked with tenants where we know discrimination is happening and they're just as, again and again, we just saw there was no way to prove it. And this, at least there is a potential of a way to prove it.
What about, I mean, option 1, you got to look into look back periods. Is it going to be 2 years? Is it going to be 3 years? Who decides? You know, I don't know, honestly. And then the other lovely thing about California are wobblers, which is a crime that can be a felony or a misdemeanor. I use to work in Virginia, where a spoken supposed criminal threat was not even a crime. It had to be in writing. And then I come to California and find out that, you know, you can make a spoken criminal threat. You know, you're upset, you say things that you don't mean, and that can be not only a misdemeanor or sometimes, depending on what the prosecutor feels like, a felony, a strike felony that then affects you for the rest of your life. I'm just wondering, how do we decide the look back? How do we don't know what the crimes are? I mean, have you guys looked at the penal code section in California? I joke that everything is a crime in California because you're going to find a code section that makes it a crime. Again, in Virginia was like this small, and then California is gigantic. So then, as Commissioner Simler mentioned before, the whole idea of directly related convictions. I actually think that option one might give more power to the landlord to find a reason, you know, to be able to link the criminal history to not providing the housing. So just some thoughts.
I think I'll just emphasize the comment from Project Sentinel, who did say that like they thought that that record was an important opportunity for tenants to say, if that, to have that brought forward, and for tenants to say like, this is my evidence of rehabilitation, or to say like, oh, that was from a database and thank you for informing me, that's inaccurate.
Vice Chair Kraus, do you have something to say?
I'm heartened by our conversations tonight. Commissioner Causey, the depth at which you've had the experience of working with people applying for housing. Chair Everly, the legal history and experience that you have wear well in this discussion. I think as a commission, we have a choice of moving forward. And the question becomes how we move forward. Do we opt for option one with carve-outs? Do we move for option two that would not have a paper trail? My tendency is, unfortunately, to think that it's option one with carve-outs, and I'd love to hear a discussion on that. But I'd urge us to take action and be exemplary in the Valley for moving forward and giving chances for equity and lack of discrimination to many people that hope to be able to someday live here and have their children go to these schools and now cannot.
Thank you, Vice Chair. I guess I have one more question because I was looking at the fair chance policies from other cities and states, and it seems like option one is more prevalent. And do you think that option two does not even really have a chance of passing if it goes to City Council?
Well, I think that in practice, there's guidance out there for landlords to have their own procedures in place where they steer clear as much as possible, whoever, you know, from doing the discrimination of protected classes and things like that. So in some way, landlords might have their procedures already in place, and this would be the city clarifying and having a consistent codified version of what the procedures, you know, what the procedures are. And so, so I think that in some way, while probably the procedures aren't exactly worded like how it would be in an ordinance in code or something like that. I think there may be just, procedures in place already that are similar to option one to, in the landlord's interest to avoid, being subject to discrimination and so forth.
What if we did option one, but modified it that if the person meets a certain formula of income versus what the rental, price is, that they would be rebuttably presumed to be adequate or a good potential renter. And then if they get denied and they do have a criminal history, then that gives them, I guess, shifts the burden or something.
Like an
To the
versus an
landlord.
opt-out in a way.
I'd be more comfortable with that.
Oh, at least like if your income is at least 3 times your monthly rent, then you're denied a rental, you need a written explanation as to why. I mean, poor landlords though, I don't want to make it harder and more expensive to be a landlord. But I do think
Most of these are institutional landlords.
most of them are, but I mean, at least that puts the burden on the landlords.
Well, doesn't option one already do that where it says there's a conditional offer and then if you rent a criminal?
Conditional offer only after they apply. There's no rule. The conditional offer only comes after they apply and they have all the information. So we're saying is that just a rule that if your salary, if you have to go sue them in civil court, there's a rebuttable presumption that you should have been able to rent this property. You understand? Because once they go to court, they have to prove the discrimination. So we would allow them to get a rebuttable presumption that they should have been. And then the landlord does have to provide in writing why. And if, I don't know what their explanation is, and then the person who was attempting to rent can say, no, I think it's because I have this conviction from, I don't know how many years ago. Does that make sense?
Again, I think that's what option one already does because you give them an offer and then I believe that option one says you give them a conditional offer, they run the report. If it comes back that the criminal is, I thought that option one says like they have to say in writing, like, I found this.
What I'm saying is that to put in the ordinance, something that gives the potential renter, like a standard of proof, I don't know.
But I guess
It's a rebuttable presumption that they should have gotten.
but does
an offer.
the fact that it's a already qualified applicant because they've already gotten a conditional offer, does that provide that rebuttable presumption?
I don't think so. I think it needs to be put into the ordinance.
I would assume that a landlord has checked the income of the applicant before making a decision as to whether to give an offer. So the landlord has already run these numbers and that's in the conditional offer.
Correct, but we don't know if they're also running the criminal record at that point. So this would, if the only remedy that this person has is to sue the landlord, it gives them evidence that they were a qualified renter, but for whatever reason, and that's why they believe it's discrimination. It's basically a shifting of the burden if you have certain qualifications.
That is the effect of the requirement to offer a conditional lease before running a criminal history check. There is no situation in which it's possible to know ex ante whether or not somebody is running a criminal history check. But in a situation where you require a landlord first to offer a conditional lease to a renter who is otherwise qualified based on their renter policies, including things like income qualification, then if the only new information that they take in between offering the conditional lease and then rescinding that conditional lease is the criminal history information that allows the renter to have that paper trail to show this is the new information, this is what changed.
Maybe I'm not making myself clear, because in the way the option one works, and please correct me if I'm wrong, they can run the criminal history when they run the credit history, correct?
Right, they are prohibited from doing so. There's no way for a court or the city to know ahead of time whether or not somebody is running a criminal history check beforehand, but this ordinance would prohibit them from doing so.
It would make it illegal, to be clear. So they would then require might help you, Chair.
Sorry, can you restate your question? We didn't quite hear you, Commissioner Kraus.
Oh, I was saying, if it's an exemption that we've stipulated, the landlord then has broken the law, and we should be able to invoke potential and penalties, which would give us recourse against each situation having to sue.
Yes, so to clarify, running a criminal history check, if the renter could prove that the landlord did it before offering them a conditional lease, would be a violation of the ordinance in the same way as denying a renter tenancy for a reason that is prohibited under the ordinance.
So I could see like potentially like housing advocates, one of their recommendations would be to ask for maybe the criminal record has to be shared with the person, because then they could say, oh, look at the date on this. I wasn't given an offer until this date. Like I could see that potentially being a piece of education that advocates could share. I'm kind of okay with one, but I would just want to have a really strongly worded guidance. I don't know, guidance isn't probably the right word, but I do not want drug-related offenses to be considered okay for housing purposes. I think there's a long history of discrimination and drug-related offenses. I think white-collar crime should be considered equally, I don't know. If we could make it very clear that drug and substance-related offenses would not ever disqualify someone, and that can't be considered related to your housing. Would that be an okay thing to add in there?
I think we would have to take that, concern back and analyze it and so forth. But if the HRC wanted to include some of these concerns that have been mentioned, some of these concerns could be included in findings. As to like some of the background as to the thinking of the ordinance and so forth, like because drug offenses are widespread
yeah, they're just more discriminatory.
Right.
Like
right.
we know that over-policed communities have more drug-related offenses. And so essentially we're penalizing people who live in over-policed communities.
So things like that information could be included in some of the findings and so forth, but staff would want to make sure that we research and cite and word things properly and so forth. So, but these concerns could be the information just stated tonight. Staff could take that back and but if you wanted to put that in specific motions or recommendations, that would be fine too. But we would need to analyze to see what the particular wording might be.
Any other comments?
I'm prepared to make a motion if there's no other comments. Oh, sorry.
Is that right if I chime in? I just wanted to call attention to one item that we didn't get a lot of targeted feedback on just yet, which would be if there was a specific look back period that might be of interest, should the commission want to recommend option one.
And is the 3-year look back that is in this, is that, you said earlier that that was based on research you had done?
Yes, I can let some of my colleagues speak to that. There's a few different bases, but that was one of the prevalent options.
Recently had proposed a new rule for their the properties that would be affected by a HUD rule for 3 years, anything longer than 3 years to be presumed unreasonable. Yeah. And the rule has not been released yet. The public comment period closed in June, so we don't necessarily have the benefit of that. But nonetheless, it was put forward. The city of Richmond does 2 years from the date of sentencing. San Francisco, the longstanding ordinance, then they have 7 years. In general, a lot of records in California only go back 7 years for different reasons and for different types of checks, like because there are different types of checks based on different types of employment, like say if you're working with children or this or that. So the records, look back differently for different circumstances. So, other states have put look back years of 2 years, 3 years, 5, and so forth. So it's fairly wide ranging. It appears to me just from a staff person looking at it that as Madeline mentioned earlier, that risk reduces over time. And so it seems to me that more recent policy work in this area would lead towards a shorter look back period relative to maybe just putting a number of year out there, like when people were thinking about this, more in the past. So staff put out 3 years in terms of, just a starting place for consideration, and would welcome feedback.
Any comments? I don't have a comment relating to the look back because, anyway, I would like to recommend or suggest that if a fair chance ordinance does pass, I'd be very curious to see how many lawsuits actually happen, to see if it's effective.
Have there been lawsuits in the past, staff? San Francisco, 7 years. Richmond is recently 2 years. There's other cities in California. What has happened?
Staff has not researched court records and so forth in these various jurisdictions.
Okay.
It's also
I'm sorry?
It's also worth mentioning that many other cities have administrative enforcement mechanisms that would sort of take the place of civil remedies in court. Staff isn't proposing that here because there aren't the appropriate resources in this city, but just It's just to say that in many other cities, a civil suit is not the only mechanism for enforcement.
What are some of the other remedies? Could you educate us, please?
Sure, other cities have like rent boards that hear these types of complaints. So it would be a similar dispute resolution process, but it's administered by city staff.
Okay.
For the reasons that you've said, and my own reason, I think, is that option one gives a much more kind of open sense that both the landlord has some interests and rights and the tenant certainly has interests and rights. Can I go ahead and make this motion that you have before me on the screen?
Yes, you may. I would just ask that if there are any modifications specifically around the question around drugs, to just be explicit in that language, because it's something we hadn't considered, and we'd be happy to just modify it if that is one of the considerations.
I don't know. I don't need a modification for.
I would
drugs.
like a modification. You said something about adding it to the findings of the report. Could we, I don't know if that's a different motion or just a modification to this motion.
I would recommend it just to be somewhat like maybe a separate clause to consider, research into what and into whatever it is that you would like to say, and for staff to incorporate in any draft before council, if that makes sense, so that we could identify appropriate wording.
So Commissioner Barr, if he is wanting to make a recommendation or a motion and gets a second, and if Commissioner Stimler has concerns, she could go through the process of a friendly amendment, but you could also just take the time to be in dialogue with each other. And if there is a more common recommendation, that comes in first, but that is up to the will of the commission.
So I will go ahead and move that the HRC recommend support for fair chance housing policy approach option one, and support for the city council consideration of fair chance housing policies.
May I offer a friendly amendment that to recommend the look back period be 2 years?
I would accept a friendly amendment to modify the look back period for 2 years rather than the 3.
Can I second it?
Yes.
Okay.
I think you needed the second first before the friendly amendment.
Oh,
So
can we go back then?
you can, I
Vice
mean,
Chair, what?
it's, as far as technicalities, that is my understanding.
So Commissioner
All right.
moves, Vice Chair Kraus seconds, and now we're going to
The friendly amendment.
friendly amendment by Commissioner Causey of 2 years, looking back 2 years.
Based upon the motion that was previously seconded, I would accept that friendly amendment.
And can I make a friendly amendment of I'd like to say an option one with a prohibition against the inclusion of drug-related offenses for the purposes of housing qualifications, but that's probably.
It's Commissioner Barr's motion.
Again, with my experience at the opportunities, that's too complex an issue to say yes or no. That so
okay, you don't want that added.
There are some drug-related offenses that would not disqualify. There might be some drug-related offenses that would disqualify. They're associated with mental illness, so on and so forth. These are all things that I've worked with before. So that.
So should we just do it as a finding with a request for additional staff findings around the potential inclusion of the prohibition of the use of drug-related offenses in housing considerations?
May I, if we did that, we need to go to the report on page 4, with the exceptions that also talk about lifetime registered sex offenders and include that verbiage, Mary Kate, Commissioner Stimler.
Sorry, Commissioner Cross, what section are you talking about in the report?
Take a look at page 4.
Sorry, I just don't have page numbers, and so I don't see it here.
Well,
What's the subheading?
Page 5, actually, exemptions. The top of the page, it's applicability and exemptions. And as you go down the page, it talks about exemptions. The footnote on the bottom is number 11. If that helps clarify it.
Yep, I see it now. So you're recommending that we add a section to this on the, so this is exceptions, which is not,
We want to stipulate an exception.
I actually kind of want to do the opposite of what they're saying here. for
Okay,
sex offense. What
never
they're
mind.
saying is that they want to protect the use of sex offense data, and I would like to prohibit the use of drug-related data.
Okay.
So maybe we could ask the staff then to include potential prohibitions around offenses that have been particularly, for which there is a historical precedence of discriminatory enforcement.
Requesting staff to research into criminal history offenses that have relationship to a history of discrimination.
Yeah, something about discriminatory enforcement.
Discriminatory enforcement.
I do want to go back for a second. If Elena, can you get or the motion is still up? I will be honest that I had to relook at Rosenberg's Rule of Orders just for the friendly amendments. And those have to be approved by the maker and the seconder. So I have to, so the 2 friendly amendments that passed, we just need to go back to to see if Vice Chair Kraus is amenable to the friendly amendments.
Vice Chair Kraus, are you amenable to the friendly amendments?
There was the 2-year, and what's the second thing?
It's the one that's written down at the bottom of the page. So to consider research into criminal convictions that have a history of discriminatory, and well, we'll add enforcement. Staff to include that in future reports to the council.
Sure. It makes it very complicated. Commissioner Barr, where are you with this?
I'm sorry, I don't have the wording down on this one, and I was trying to give some sort of indication that this hasn't been passed yet. So I would like for us to work on this wording before you go on to agree to it, please.
I think we're just collecting people's thoughts on the
Yes.
wording. We'll nail down the wording and then we'll vote on it.
It is, but if there's not clarity about what the friendly amendment is, I've been kind of multitasking here. I think, is that clearly indicated on the?
Should it be bolded 2 years?
I'm just saying, I just want it written that it is clear what the 2 friendly amendments are, or that we have.
There is one friendly amendment so far
Okay,
that has been agreed to.
thank you.
Correct.
That's for the motion. I guess the considering the research is not part of the motion.
Not yet.
So the question is whether we like this wording. I would like to use history of discriminatory enforcement. And and then maybe we can add and possible recommendations to prohibit the use of criminal records related to convictions with a history of discriminatory enforcement. Essentially, if we're going to allow, if we're trying to prevent discrimination, but we're going to allow the use of convictions that have a history of discrimination, it just seems like we're going to end up with people saying, oh, they have a drug-related offense, that's related to their housing, and then we're going to just end up with a rule that doesn't achieve what we're hoping to achieve. So that's.
I'm sorry, I just, after possible, if you could
Okay.
fill me in again, please.
Consider research into criminal convictions that have a history of discriminatory enforcement and possible prohibitions against the use of convictions that have a history of discriminatory enforcement.
Could I just chime in here for a second with a small recommendation?
Yeah. On the wording of this one? Yeah.
Just more on the structure, actually. So I think what might be the most effective at this point would be for the commission to look primarily at the wording of the motion itself. And then it will sort of fall on the city attorney's office and the planning department to then interpret what we've heard here tonight, including a lot of what we were just sort of talking about in terms of supporting additional research, and package that into the council staff report and such. So I actually might recommend we not necessarily need to put down here specific wording around those criminal convictions, and say instead that we support particularly the city attorney's office looking into additional research in this area. And so we can take into consideration kind of what's been voiced here if we feel like it's representing the whole commission's, interests, but we don't necessarily need to put it into the motion itself. And that will just give staff the flexibility to do a little additional research on this very nuanced subject and bring forward an option that considers this when we do go to council.
That's the option I prefer, is to have this second part simply to be a recommendation from the HRC, but not part of the motion.
I think that's not what she was saying, though. I think she was recommending that we have a motion that's just more broadly worded. Is that correct?
I was just saying maybe that last bit, directing staff to do research, maybe we not include that in the motion itself.
Oh, and not in the motion.
Sorry.
Okay, sorry.
And,
You're
and
right.
just to
Sorry.
clarify,
Commissioner Barr, you're correct.
it would be
Okay.
staff research, not necessarily city attorney research. So,
Yep. Okay.
we'll tag team on that one, but.
Okay, so two motions, and this motion and then a second motion. Is this,
Not if the second motion is directing staff to do something. That is not within the purview
Oh.
of the HRC. So they can listen to your feedback and see if
Okay.
it's relevant to work that they have been asked to do for the city council,
got
but
it.
not specifically to direct them to do a task.
And I can just assure you that we've been listening carefully and taking notes, and that we value, what we're hearing tonight. And unless we were hearing lots of dissonance among the commissioners, that would be our only concern. But if there's, general interest from the commission in some additional research that could be useful, let's encourage that. We're listening to that, we're hearing that,
Okay.
but you can't really give the formal direction for
Got
us to do it.
Got it.
Sorry.
Okay.
Got it.
I also want to give the open feedback for consideration of, I know earlier we were discussing if this would be more effective if we included violating this ordinance includes a fine of
Yeah.
this much or some other incentive. So just openly stating that feedback.
That feedback has been heard.
Are we ready to vote?
Oh, wait. Sorry, but should we add her point as a friendly amendment in the sub bullets then? Something around penalties and fines,
Please.
inclusion of any additional procedural protections beyond, and then one of those could be penalties and fines. Or no?
Yes, from this person.
And is it beyond or is it including?
I think the wording in that slide was from the staff presentation saying we'd be looking for any feedback on, we'd be looking for feedback on any additional procedural protections beyond what was already listed. So if everyone is fine with the ones that are already listed, perhaps it would be inclusion of or consideration of the additional procedural protection of or inclusion of, I guess it would be like an enforcement.
Can I suggest a simple, what I meant by the friendly amendment? At the motion as it stands, with the friendly amendment would say, support for fair chance housing policy approach option 1 with a 2-year look back period, and support for the city council consideration of the fair chance housing policies.
And then just for extra clarity here, I think we do want to just remove the word beyond in terms of if this is the motion language, because as Rebecca noted, that was sort of a holdover from the slide presentation. And if you guys did want to add anything beyond what's in those sub bullets, you are able to do that.
Sorry, so I think what Commissioner Causey is recommending is a sub-bullet in that list of bullets that would include potential penalties for the misuse of criminal records.
Please.
I don't think, Elena, if the friendly amendment has been approved, I don't think it needs to be in the motion anymore. Then it just becomes a part of the motion. No, you just don't need, oh,
Yeah, I think you can.
No,
That wasn't word of the friendly amendment.
no, we're not doing that word.
The friendly amendment was simply changing 3 to
It's
2.
just clearing up the motion.
Period, end of story.
Because this is all for reference. Okay.
Option 1 with a 2-year look back period.
You would keep that phrase in.
Yes. But not and additional potential penalties. That is not part of the friendly amendment. To look back, 2-year look back period, 2-year look back period. Well, this is my motion. That's the only thing in my motion.
I thought this was just going to be just. Meaning your motion is just that one sentence motion and then that one sentence and
all the other things are just suggestions. So the motion is just
To approve option 1.
with a 2-year look back
the
period.
2-year look
Right.
back period.
And everything else are just recommendations for them to look into from HRC, not binding or in any way.
I think if I understand you correctly, Commissioner Barr, you're saying that your recommendation is what your motion is one sentence as reflected at the top of the page, and all of this other additional information we've just been looking at for reference.
Correct. That's just for your awareness.
But do we need to have a definition of what option 1 is?
Well, it is on this paper here, and.
No, because it's in the report.
you could
In the
put
report,
per
yeah.
the staff report if you want to be specific as per the staff report. You can do that.
Okay, I'm comfortable with that.
Okay. Everybody ready to vote?
Yes.
All right, Vice Chair Kraus,
I,
Commissioner Shea,
Aye.
Commissioner Barr,
Aye.
Commissioner Stimler,
I,
Commissioner Causey,
Aye.
Chair Eberly, nay. Can I make a statement? Um, Being that the only proposed remedy is a civil lawsuit, I feel that the bar is too high. I like the idea of the shifting of burden. I still believe that the ordinance should have a formula of income versus rental cost, which would give the renter a rebuttable presumption that he should have received a conditional offer. And also the fact that there is no administrative enforcement mechanism in a city as rich as Palo Alto is upsetting to me. And it does tell me that maybe the city is not serious about a fair chance housing ordinance. And that if they are, that they should create a budget for it. I mean, to expect these people to go to court and sue and prove their case, I think it's a very high bar. So, thank you. We are not going to take a break.
we're not.
Oh, I'm sorry. Motion is passed. What?
Oh, I thought we were gonna have a, sorry, I just got confused.
No, those are just recommendations.
Or, okay.
That was just
So no
feedback.
penalties.
Yeah.
Okay. I. I apologize.
Unfortunately, you aren't able to direct staff
I know
in
we're not-
the
but we're gonna
motion,
do
but
something-
it's been heard and it's definitely considered.
On both
It's
the
just
penalties
feedback.
front, on both the penalties front. and
Penalties and drugs are both topics we heard tonight as important and requiring additional staff research and consideration before this topic comes before city council, which would be our next step.
And I hope that the staff would also take my feedback into account.
In terms of
One
additions to
commissioner.
civil, yeah, we can definitely do additional research on that and discuss it. And those are the sorts of things that are also great to discuss in the council context. So just because something isn't necessarily in the motion doesn't mean it won't make it into the council staff report.
Great, thank you.
Thank you. Thank you so much for coming and,
Some more people to come and talk about this next.
sorry, and for the presentation. Thank you so much for joining us.
Thank you all. And just a reminder that we have 15-minute break. And just a reminder of no conversations while you're there or when you're back on the dais during this meeting. Thank you. Pardon? You can ask them questions, but not speak to your fellow folks. But yes, you are allowed to open your mouth there.
All right, we are back from our break. So we are going to do the next business item, which is a discussion of the proposed 2025 City Council regular meeting schedule and the draft citywide list of holidays and dates of significance. And odd. Is this an action item? No, it's just a discussion, correct? Sorry.
It is just a discussion to
Okay.
provide feedback to staff, Chair.
Thank you, because I don't have the edited version, so I know the first one got moved to action, so I just wanted to clarify that this one is still just
Sure.
discussion. Thank you. We are going to have a presentation, and then we're going to go to public comment, and then we'll ask questions, and then have discussion. So Minka, do you mind introducing
Sure.
our speakers?
Having a nice night always, introducing all my colleagues here in front of the HRC. So I'm pleased to introduce my three colleagues. Deputy City Manager Chantal Cotton Gaines, Deputy City Clerk Christine Pryor, and Diversity, Equity, and Inclusion Program Manager Kojo Pierce.
Welcome.
Thank you. Good evening. As Minka said, my name is Chantel Cotton Gaines. I'm the Deputy City Manager, and I also work with Kojo with leading our DEIB efforts, race and equity efforts at the city. The item before this evening, this is our first time bringing this to the Human Relations Commission, and part of that is aligned with a few different initiatives at the city, which I'll talk about on the next slide. Actually, you can go to the next slide. Thank you. So there's two things that we would like to cover this evening, which is in your staff report. Looking at the proposed city council regular meeting schedule in context of dates to avoid scheduling something on a council meeting. And the second is the draft citywide list of holidays and dates of significance to increase awareness. Next slide. As I mentioned, this is our first time coming to the HRC with this item. It comes from a few different directions. One is annually the city council does approve their calendar. In the past few years, and Christine will talk about that process, but in the past few years, we've tried to be clear of what the dates are that we would cancel a city council meeting for and be able to explain that to the city council. So we are just trying to add a little formality to that process. And the thought was coming to the Human Relations Commission is it offers us the opportunity to hear feedback based off your experience, as well as feedback from the community on if we're missing something or if you have suggestions of things to change. It is an iterative process. You'll hear that word at least 5 times during this presentation today. It is iterative. We are not proposing we have everything correct, but that's part of why we want to have this conversation in a public space so that we can all work together with the intention of being more inclusive in our community. The city council is the second bullet point, discussion of dates of significance. The city council has brought up a few days they wanted the HRC to work on. You all did amazing work on that. And this is an outgrowth of that effort as well. Our equity action plan has about 30 action items within it, which we can share with you, and the link is here. One of them is item 1.3, creating a process that includes the HRC for annual calendar setting related to holidays and heritage months. So this one is trying to connect the council's annual process, as I talked about, and link in these dates of significance. Lastly is the desire to have this as an annual process. Iterative one more time. The intention is year over year, we can continue to refine this as we hear feedback and see something worked or didn't work. We have the opportunity to keep growing together in the process. And with that, I will turn it over. Next slide, please. And I will turn it over to Ms. Pryor.
Good evening. Like Minka said, my name is Christine Pryor. I'm the Deputy City Clerk for City of Palo Alto. And I'll start by just giving some background about how the council sets its calendar every year. So as you can see here, the Palo Alto Municipal Code sets out when the city council will regularly meet. They regularly meet the first 3 Mondays of every month at 5:30. The council has previously in past years modified this set calendar to avoid certain days. Those have generally been city holidays, local elections, which tend not to affect city council meetings, but more committee meetings, And then the last category are religious and cultural days where the city council is given direction to move a meeting. So these modifications have varied year over year. They're not the same every year. So part of one of our desires with bringing this to your HRC meeting this evening is to bring some transparency and consistency to the process. So staff, the council, and residents know what to expect year over year. And like Chantal mentioned again, we have not brought this to the HRC meeting before, but we would definitely value your feedback and the feedback of community members on anything that we missed, anything to change. Next slide, please. So with that history in mind, the proposed calendar in your staff report was created to avoid these dates to avoid for meetings. These dates are proposals only. This is recommendations that we would definitely like the commission's feedback on. And these proposed dates to avoid fall into two main categories. The first are city recognized holidays and days when the city facilities and administrative offices are closed. The second category are religious and cultural holidays whose celebrations generally begin in the evening. So observers would be precluded from participating in city council meetings if one was scheduled on one of those days. Our goal with this process is to increase the transparency and public awareness of how the city council sets its calendar, and to recommend a calendar to the city council that's consistent with the city's commitment to equity and inclusion. And we are not looking for the HRC to be experts in how different people celebrate different holidays. What we would greatly value this evening is just your initial feedback on the calendar, these proposed list of dates to avoid, and any recommendations for how we can improve this process moving forward. And with that, I will turn it over to Mr. Pierce.
Good evening, everyone. Thank you so much for having us. Once again, my name is Kojo Pierce, the DEI manager for City of Palo Alto. So first, I'm going to talk a little bit more about our process, our purpose, commitment to equity and inclusion, and also the importance of visibility of these dates. We want to start by saying that this process is iterative, as Chantal already mentioned, and we're open to suggestions, as we hope this will be an annual discussion at the HRC. The list of holidays and dates of significance in attachment A is a draft list, and we hope to receive feedback this evening. Now I want to go over the purpose of this list. So the first thing is to show the city's commitment to fostering a more inclusive city. The second thing is to increase awareness, expand visibility of dates that are important in the Palo Alto community, and also for the general recognition of, or sometimes proclamations, In this initial discussion, we're not looking for the HRC to decide how we celebrate these holidays of significance, but instead, we are just firming up the list with all of the feedback. This list could also be later used to link the previous HRC discussion around different ways for these to be observed. This also relates to our Equity Action Plan item 1.1, but this is not the discussion this evening. We look forward to the HRC and community thoughts on this list as well. Thank you.
Next slide, and we will work towards wrapping this up. And your lovely council member liaison has already pointed out at least two things that we need to add to the list of dates to avoid. So that tells you how awesome your commission and your liaison folks are. So this is just a summary of, again, what we're asking for this evening. I know the discussion on holidays can be very broad overall, and there's many more steps that we can do. Today's discussion is very narrowly focused on the two things, the things that impact the council calendar, and then that long list, which actually will guide some of our work on other items in the equity action plan, as Mr. Pierce referenced. So we are not trying to skirt the conversation around those items. Just wanted to be clear that isn't the focus of the items being brought to you this evening. And with that, we will pass it over to Minka, who has received some feedback. I'm not sure if it's appropriate to share that now or after.
Yeah,
thank you.
As part of the outreach for this or in any HRC agenda, sometimes we do get letters to the HRC, and to staff sometimes. They direct it to me. So at the point that you would like, I can just name the suggestions that I've already received whenever you see fit, Chair.
You can go ahead and do it.
Okay, so
Please.
I received, hold on. So I received suggestions for 3 days. So 2 holidays. One is Shavuot. I'm sorry if I'm mispronouncing that, and Sukkot. And those are both holidays in which the writer of the email said would preclude individuals from coming to from council meetings. I do notice that Shavuot is listed on the larger list. And then the third that I got an email about is Nakba Day. And there was not any additional text that talked about where that individual saw that. So those were the 3 suggestions that I received.
Minka, what was the third one? I haven't heard of
Nakba
it.
Day.
Nakba Day?
It is, it refers to an observance of the displacement of Palestinians during the 1948 Arab-Israeli War.
Can you spell it for me? Or it's
It
on this
is
list somewhere?
NAKBA.
NAKBA.
And those were the
Thank you.
suggestions that were given to me.
And if that,
List?
What I said is the first one,
Oh, okay.
Shavuot. I'm
Thank
sorry,
you.
again, if I'm mispronouncing it.
and the 2 days that were referenced to us that were incident or left off or Labor Day on the dates to avoid, which we clearly are not open for or have meetings on. And there was also a suggestion related to Easter, which is always observed on a Sunday, but that is a question of if to list on the list or not. Thank you, Councilmember Lithcott-Hames, for those.
Well, I noted that Labor Day was missing, so that started me on a hunt for what else might be missing. And it just occurred to me that visually, even though Easter is a Sunday and we don't have city meetings on Sundays, somebody could look at the list and decide we've overlooked a major Christian holiday, even though there are many major Christian holidays on the list. It just felt like it's missing for anybody who's really concerned that we're not being inclusive. I would err on the side of including that one.
Wait, no, we're going to go to public comment first.
Okay.
Minka, do we have any public comment?
No, we do not.
Okay, well, I appreciate the city staff coming and sharing this with us. I like the idea of transparency, and I like the idea of having this annually. And I know this is the first time, so maybe this time we don't get anybody coming, but now they'll know, they'll be setting precedent, so they'll know next year that you're always gonna come here, and then people then can come and actually make public comment. So
For clarity, there was some outreach that was done, and that's indicated in the staff report.
That's true. And also the emails that you got. That was also.
Correct. And there's also our constant contact list, which goes to several hundred people in the community.
Great, so people were unnoticed. But I do appreciate the transparency efforts and the inclusivity efforts. So now we're going to go ahead and see if there are any questions from the commissioners, and then we'll open for discussion. If you have a question, please let me know, raise your hand, or Commissioner Barr.
I guess my question is this will be available somewhere on the city website?
Correct. So the staff report is a public record, and whenever the city council adopts its calendar, that will also be public, and it's listed.
So there are a number of days on here that I've heard of before, but I couldn't tell you what cultural, religious, or other group observes that day. I wonder if there might be a several word descriptor of what cultural, religious, or population group observes that day. So people who look at it and say, oh, yeah. because I am ignorant about a number of these.
Thank you. And if I may clarify, Commissioner Barr, are you referring to the big longer list or the shorter list or both?
I think I was looking at the longer list.
Okay.
Yeah.
Thank you.
Go ahead, Commissioner Simler.
I'm just curious why Lunar New Year wasn't considered to be one of the days to be avoided. We have 35% of our community is of Chinese heritage, and that one I know is a pretty major holiday for them.
I was also going to ask a similar question about is there going to be, I had the exact same thought, and I had that thought about multiple days on the longer list. Is the process, are we doing more research on dates on the longer list, and they might be included in the ones to avoid going forward?
I'm not used to this microphone, so excuse me for my slow clicking. So to the Lunar New Year question, we looked at a couple of things as Ms. Pryor referenced. Not all holidays are celebrated on days that impact city council meetings typically. So like Lunar New Year next year is on a Wednesday, the starting day. So we did try to look at when the day hits. So we can go back like a 5-year, 10-year look just to see if we're seeing it land on Mondays, but I think that is a good one to have, sort of just making sure. And the other piece that we wanted to look at was when the celebration of a holiday starts in the evening time. And so that was one of the criteria that helped us not have like a very, very long list. So I'll use one that is probably not too contentious, is like Cinco de Mayo, for example. It's like a lot of people celebrate it throughout the day, or as opposed to some of the other days where we know that it starts at sundown on the first day of the celebration. So we tried to look at it from that perspective, but that is definitely not saying we captured it correctly 100%. So we're welcome to feedback.
Can I just ask a clarifying question? So these holidays, this list, are they just holidays that can fall on a Monday, or they are falling on a Monday next year?
The former, they could fall on a Monday.
Okay, so Lunar New Year could fall on a Monday, right? Okay.
Yeah, so we can add that one to the list. I just want to double check it, but yes, we can add that one to the list.
And Diwali also, I would think, could be added, considering the
Many days.
what?
Yeah, it's on the list.
Not on the longer, not
It's
the
on the
first
longer list.
list. I'm no expert. I was just Googling it, and it starts on one night. Not this year.
Yeah, I just had a question on how the dates of significance were picked. I mean, how did things get on the list?
We did a lot of research and we probably didn't capture everything, is probably the most honest answer we can give. So we looked at sort of list of popular holidays. We looked at holidays that are celebrated in our region. We just tried to see what we can find. And as you look up holidays, there are hundreds. And so we tried to synthesize hundreds to a page or so, but if there are more from the hundreds list that we are missing, we definitely want to add them.
Yeah, I was just thinking that we have such a diverse community. Maybe there could be some community input.
I think that was one of the intentions of this meeting, that we could get community input. I think as a first pass to the HRC, we're just hearing this, and as this is an iterative process, like Mr. Pierce said, that as this continues to come to the HRC, we can look into ways in being able to hear from more of the community on holidays or days of significance that are impactful and important to their community.
And also, Minka, well, the framework that we recommended to City Council.
Yes, so the framework that you suggested to City Council, your recommendation was that it would come back to staff. So most of the people at this side of the room tonight have been talking about that and will continue to be in dialogue regarding any type of process. I think yours was a little bit more into what level of celebration or support that a certain day might have. So we are still, we are still in that conversation with each other. I think with some of these things, we're getting towards December, so this is kind of jumping the list on needing to get this list to the council and realizing that maybe not all the specifics that you might see next year are in place.
Okay.
Thank you. Vice Chair Kraus?
No comment at the moment. No comment at the moment.
Do you know, I have a question. How many then of these holidays would fall on a Monday next year?
No, not at this time.
Okay. I'm just wondering how many meetings would actually be canceled.
But that is definitely something that we can look into, and when we bring this to the city council, we can include that.
I think it'd be interesting to see, the impact. And the good news is that I see a lot of room for special meetings. So I think it's going to be kind of a game where, if you have a room for a special meeting and there's no real harm in moving the meetings, then it can be canceled. I guess there's like some kind of feasibility issues. Okay. Any other questions before we go to comments? Any comments? Nothing. Okay, well, thank you so much for coming and sharing this with us. I think, again, I'm thankful for the transparency. I'm sure the community is thankful as well. I'm glad that our list of holidays is so long, and I think it's important to have it on the website and share, and I would love to hear, more things being done around these holidays. So thank you so much.
Thank you very much for having us this evening. And if you do hear feedback after today, especially on the longer list, please do share that with us. The longer list is very easy to edit throughout the year as well. So we appreciate the engagement and look forward to this conversation annually.
Thank you. And also I would look forward to maybe, having the framework and the long list interact and having people feel empowered to take action on the holidays that they feel are important. So thank you so much. Okay, so now we are going to move on to, no, it's commissioner reports, staff reports. Hold on. Commissioner reports. Does anybody have a commissioner report? Okay.
Wait, is tonight where we're supposed to speak about our visits to?
Yes.
Okay.
Yes.
Okay.
That would be great.
Awesome. Well, I had a really wonderful visit with the Vision Center on El Camino Real. It was really, really phenomenal to hear about everything that they provide to the community and the work they do. It's super incredible. And give me a second. I'm trying to remember everybody that I had a visit with. So it was the Vision Center. You might have to come back to me. I'll need to remember the other one that I went to.
Commissioner Shea?
Sure, I had 3 Zoom meetings. So the first one with Jessica Yee, Director of Development, Planning and Evaluation at the Ravenswood Family Health Network. And there were 3 members of their clinical staff on the call. And then I had a meeting with Sophie Pigman. She's the Program Director of the Opportunity Center at Life Moves. And The third one was with Andrew Navarro. He's the Associate Director of Clinic and Outreach Programs at Peninsula Healthcare Connections. And they were all really compelling meetings, talked about, the experience of their patient populations during COVID-19 and afterwards, talked about challenges, in this economic climate, and so it's just very wide ranging and really compelling. And I really enjoyed all three meetings.
Oh, the other one I was going to say was La Comida. I went and had lunch with La Comida. It was so much fun, and it was really hearing from the seniors that it is such an important social place of social interaction for them. There was one couple I talked with where he and his wife is very housebound these days, and it's really a great opportunity for her to get out. And I think my favorite conversation was with an older gentleman, and where I was asking everyone how long they'd been going, what brought them here, and he said, "I met my girlfriend here."
Oh. Thank you. Commissioner Barr, and then we'll go to Vice Chair Krause. I saw your hand earlier.
Yeah, so I had my 3 visits with Project We Hope, which is actually in East Palo Alto, that Pastor Paul Baines and the truck that goes around and provides showers and things. I didn't realize this. Since the Opportunity Center is closed on Saturday and Sunday, their truck comes over and parks at the Opportunity Center and provides those services to the homeless in Palo Alto on Saturdays and Sundays. So I thought that was very interesting and very worthwhile. Likewise, I talked to the Downtown Streets team that provides a lot of support, and it helps, the funding helps them to maintain the staff to reach out and do working with homeless there. And then I had never heard of Senior Adult Legal Services, SALA, Senior Adult Legal Assistance, SALA. They were founded here in Palo Alto in 1973, and they continue now. They have offices throughout the Bay Area, and they come to Avenidas on a scheduled basis, and people can make appointments to get legal advice from there, and then some of them, they continue on providing the advice, but I was not aware of them. They do a very important work.
Thank you. Vice Chair?
I only had one very wonderful meeting with Evelyn at Carrot. And our topic was lengthy about the RV dwellers that she serves, and continued bafflement of their displacement. And we had a lengthy, in-depth conversation, which will go on for many years and many eons.
Thank you. Thank you for that update. Commissioner Simler?
I met with Alto Housing, Beatrice Pastor, and we had a great conversation about the way they've been using his rep funding to benefit after-school programs and summer programs for the students who live in the Alto Housing. And then I also had a conversation with Dreamweavers, Nicole Chu Wang, and what did I say? Dreamweavers. Oh, dream catchers. Sorry, dream catchers. Yeah. And it was interesting that both are have a lot of after school programs, and Dream Catchers has a lot of mentoring opportunities for high school students. In fact, my babysitter right now is a Dreamcatcher mentor. And Alta had also mentioned that they were looking for increasing their mentor programs, and so reminding them to connect with each other. And then the other interesting thing was that in our last HRC meeting, the need for public or transportation for senior programs came up when we were discussing elderly programs. And the very same need was actually also felt by both of these programs, that serve our youth. That often there's a lot of interesting opportunities for youth in our community, but the challenge is getting them to the places that they could go for field trips and that sort of outing. So it was just interesting to hear that need being reflected from our youth programs, just as it was in our elderly programs.
My daughter was also a Dreamcatcher volunteer for 4 years in high school. I think it's a really great program. Well, are you done? I'm sorry. Thank you. I had all my 3 visits. My first visit was with the YMCA. I met with Delazio Emerson, a senior executive director. I was particularly impressed. I actually go to the Y, so I knew the facility well. I love that the Y serves everyone from kids to people with small children. They're one of the only gyms, I think, that provide childcare, so you can work out if you have a small child. And now if you're 8 or up, you can also exercise along with your parents. I was very impressed by all the programs that they have for seniors. They have a Parkinson's program, they have a strength and balance, they have a diabetes program, they have a Live Strong program. They also have a health fair connecting seniors with services. And they have a sliding scale, so they try to make it affordable for everybody so everyone can join the Y and feel a sense of community at the Y. Then I had a Zoom meeting with Lori McGilpin from the Children's Health Council, also very impressed. So they service children with mental health and learning challenges, including ADHD, autism, severe anxiety, depression, suicidal ideation, and learning differences. She talked about, all the free resources that they have. Again, you can go there for free. Also, they try to provide services for as many people as they can, and they do have a sliding scale as well. They have a community engagement division where they go to the schools and they offer presentations, and they also help with teacher training. They are a PAUSD partner. The grant that they have from us, with that, they've been able to help clients access their services. So they help with food, vouchers, housing, transportation. What they find is that there's a huge need of eliminating barriers, again, so people can get to the treatment, to get to the therapy. And then my last meeting was with Ada's Cafe. I went there and had a lovely meeting with Kathleen Hughes, who's a founder, and also met her son, who is a co-founder who works there. And their mission, as she explained to me, is to hire, train, and elevate people with disabilities. And I didn't know this, but they serve all sorts of different disabilities. So you can be neurodiverse, severe anxiety, vets with PTSD, people with traumatic brain injuries. They had a refugee who had a hand blown off, used to work there, and even formerly incarcerated. So while I was there, I did witness 2 of her employees working together. One of them had difficulty with maths and the other one with recognizing social cues. So they were both basically teaching each other by working. He was teaching her math. It was really nice. And she is able to provide these breaks where they can, they're not only working, but they're also learning while there. It was very nice to see. So definitely a pillar of the South Palo Alto community. She pointed out to me that besides Pete's, they're the only cafe in South Palo Alto. So I think the more we go to these places, it makes our job harder because you see what wonderful work all these not-for-profits are doing. So it's really difficult when it comes to divvying up the money. But I appreciate all our not-for-profits for also taking the time to meet with all of us. We really appreciate it, and you are doing wonderful work. Okay. Oh, I also attended the Teen Mental Health Summit, and Commissioner Barr was there as well this past Saturday. Very nice. I did not get a chance to attend the workshops. Commissioner Barr, did you attend any of the workshops?
I went to a couple of the workshops, but I also had the chance to connect to Dr. Shashank Joshi, who is the Stanford adolescent psychiatrist. And I talked to him, and I'm may follow up with him on some other issues around adolescent mental health.
Thank you.
Oh, and recently, on September 17th, I went to an event at Palo Alto High School. It was called AAPI Youth Mental Health Opening Intergenerational Conversations. And it was sponsored by the Pali Associated Student Body, Asian American Foundation, Third Street Books. So there was a range of really compelling panelists, students, parents, school administrators, and it was really wonderful.
Yes, I wanted to go to that, but I had a conflict. I feel like it was some, oh, yes. I think the conflict was that I went to the, my God, Cara dinner that they invited us to. That was also, it was a, thank you. On that, what?
On the same night.
I believe it was the same night. I think so. Anyway, I also went to the Cara dinner, which was very nice, learning about what they do and all the impact that they have in the community. They are the grief organization. They provide, I really love the way that they provide therapy services, group therapy, and then they take into account, they try to create these groups that take into account people's background, and they take diversity and different communities, and they try to group them. They also go to schools and have grief counseling groups there. And they, again, work with all ages. I was very impressed. Again, I feel that Palo Alto just has a lot of not-for-profits, and they all do wonderful work. So thank you. I think that's it for, Vice Chair Kraus.
There's two other things. One is I want to thank Commissioner Stimler and Shay for coming to the Evening of Remembrance on Monday evening, October 7th. It was good to have my commissioners with me at a very somber evening for remembrance of those lost on October 7th. Is this the right time to tell you about the update of the security meeting?
Yes, definitely.
All right. Well, Minka and Daryl and I have continued to work. The meeting is ready to go on the 15th next week. And we're hoping that you can all attend and that you've been able to reach out to your constituencies. We're looking forward to a very important discussion. Our captain from the police department will represent Palo Alto. We have the assistant agent in charge from the FBI, and we have our district attorney, Rosen, will be there speaking. Our mayor, our Greer Stone, will be moderating the discussion. And we hope that everyone can come and be better equipped to deal with the issue of hate crimes in Palo Alto.
Thank you. Okay. Council member, do you have anything for us?
I do. Thank you, Chair. Always a pleasure to be your liaison. Enjoy listening to your meetings. I have just a couple of things. One is that we are bringing forward a resolution on council at our next meeting. So we're not meeting this Monday because it's Indigenous Peoples' Day, but on the 21st, we have a council that Ms. Vanderswag has really pulled together, along with help from LEFAB and with Palo Alto childcare community. This is a resolution in support of childcare, and it was urged upon us by an organization, Build the Future, which is a movement to build a brighter future for all Santa Clara County residents by advocating for affordable, quality childcare for all. So Supervisor Susan Ellenberg had asked if I thought Palo Alto would be the type of community that would want to publicly support childcare and the importance of quality, affordable childcare. And I said, yep, I'm pretty sure we've been doing that and we are proud of that. And we're in many ways a leader in that regard. And anyway, so we'll be having an opportunity to recognize our efforts here. It's the second agenda item on Monday night, probably around 5:45, 5:50. So for anybody interested in childcare as a matter of equity, I think this is something to really celebrate. And again, thank you, Ms. van der Swag, for pulling the laboring oar on that to pull it all together. The second thing that I want to report out on is the Cubberley deal. As the community knows, the city and the school district were able to reach a deal for the transfer of real estate from the school district to the city so that the city can build a brand new community center if the community ultimately decides to vote for it in a bond measure that'll go before the voters 2 years from now. The reason I'm raising it is I think inherent in the creation of a brand new community center are a whole slew of potential equity and belonging and fairness issues that could be overlooked if the right lens and the right light isn't shone upon everything conceptually from the beginning. So colleague to colleague, I just invite you to think, I don't have anything in mind as I say that. I'm not like trying to hide the ball here. I just invite us all. I would say the same thing if we were talking about the coordinated area plan for San Antonio Road or the downtown housing plan. When anything big and new is contemplated, I think it behooves those of us who are really trying to bring that lens of equity to every conversation. It behooves us to think, you know, what do I need to try to notice? What are the questions I need to try to ask well in advance of when the thing is designed? We don't want to find ourselves after the fact, assuming the voters vote for it, assuming we build it, assuming they come, right? We don't want then to find out, oh my gosh, we failed to consider something that will seem terribly obvious to us 5 years from now, 7 years from now. I'm inviting us to be curious about how can we get in front of it? How can we imagine what the issues of belonging or lack thereof, of access or lack thereof, of equity or lack thereof, how might those manifest and how can we make sure that that doesn't happen on our watch?
Quick question. So is the city keeping it as a community center or are they considering housing or any other uses?
So the concept as described is a community center. The last time the city dove deeply into this was 2019 with the school district, thinking about a jointly owned and operated situation. And that fizzled. I think we're going to be starting with those plans. They got, it was very built out. The plans were very detailed. It's a good starting point for us. The question of housing was very controversial in those years and may still be very much on some people's minds as a positive and very much on some people's minds as a negative. So that particular facet has in no way, shape, or form been decided upon, certainly not in the affirmative. I think there are many people who think, no, there shouldn't be housing there. So I think housing there is an open question. Community center, even what comprises a community center, what are the components that have to be there? What do we have to keep from the current Cubberley? I think that is all part of the community conversation that will ensue pretty quickly, and it needs to be completed in 18 months in order for us to put the bond measure together, describing what it is we're asking the voters to approve.
Thank you. Staff?
I don't have anything to add. I just still have flyers for the event next Tuesday. There won't be a quorum of the HRC, so it'll just be a community event, but still look forward to you passing it on to others that might be interested in attending.
Thank you.
Will that event be recorded for those who can attend?
No, it will not be. It will not be.
Vice Chair Krause, is that a hand or no? Okay.
No, it's not. I'm sorry. It's not a hand.
Okay, thank you. All right.
Thank you.
Okay, any final questions, comments, announcements, or future meetings and agendas?
I would just say the next HRC meeting is scheduled for the 23rd to go over the Human Services Needs Assessment. If the draft report is not ready to be presented at that time, staff will let you know.
Thank you. Okay, meeting adjourned. Thank you. Have a good evening, everyone.